Use this mic so that you can see me and I'm not a toy professor. I'm coming at this from a rather different direction from everyone else. In 1978, believe it or not, I had a sort of moment of insight when I realized that the entire legal system was going to have to be reconsidered as a consequence of digital technologies. And so for the past 30 plus years, I've been looking at the impact of digital technologies on a number of different areas of the law. There was a longer introduction that she skipped, but the 25-year book there, which is now going into its second edition, was Change of State, Information Policy and Power, that offers a way of theorizing, conceptualizing, and historicizing information, law, policy, and doctrinal principles across all areas of the law so that we can see them commonly, and then it looks at that in depth in 32 different areas of the law. My work in the area of cybersecurity in the past, in the 80s, I was looking at information policy and arms control treaties where there are actually literally dozens of provisions, and in the world of competence and security building measures, perhaps the mirror side of what we're concerned about here, that became extremely important. For obvious reasons in 1990, I dropped that, but for other obvious reasons, I've come back to it now, and I thought this would bring us, wrong clicker. Okay, human skills fail us. Yes. Okay, so the argument I'm making here, and it's been well set up by the speakers who came before, is that the points of disagreement among the international group of experts responsible for the Tallinn Manual's treatment of cybersecurity, that's just the first 19 rules of the manual, mark the challenges presented by cybersecurity to the nature of the Westphalian system itself. What I'm going to do today is cover these topics. And the little bit of history I wanted to offer is that actually the first time that there was concern about vulnerabilities of the state was in the 1970s. That was first published in a report called the Tallinn Report to the government of Sweden, and pertinent to our current cybersecurity concerns. The issue at stake there, what inspired them to be concerned about vulnerabilities, meaning damage to the state itself as opposed to sensitivity, some harm but not disturbing the nature of the thing. The vulnerability of concern there actually had to do with fire stations. In Malmö, Sweden, they were using an automated system that was with information processed in the US, and they started worrying about what would happen if the US got mad at Sweden. But the 1970s is an important decade here because that is, of course, when people started thinking that, realizing that the nature of the state itself was changing. There was a brief moment in which there was discussion about the decline of the state. That went fast. We know what really happened is that the nature of the state changed, and my argument in Change of State is actually that we have replaced the bureaucratic state with the informational state. We know that, to put another longer history on what we're talking about today, historians of the law talk about contemporary transformations of law, state, society relations as equal in importance to the transformations that took place in the mid-17th century when the Westphalian system itself was constructed. So the long-term expectation is for a completely new configuration of law-state society relations. My personal guesses we're at least a couple of decades away from that, and what we're in now is the turbulent period of negotiations over what that new configuration will look like. In terms of talking about context, just a little bit on the theory and concept side, political scientists have, of course, for decades been talking about three phases of power: instrumental, control over the material world; structural, controlling your behaviors by controlling rules and institutions; symbolic, control over your perceptions, thoughts, and ideas, what Joseph Nye refers to as soft power. And I'm arguing that there is a fourth form of power which has become dominant today, which I'm calling informational power, which controls the informational bases of power in its instrumental, structural, and symbolic forms, and offers some new tools of power that were never before historically available. Drones and robots, which have come up today, would be examples of the informational impact on instrumental forms of power, and I could work through the rest of that in Q&A if you were interested. Political scientists also have historically talked about the difference between actual and potential uses of power. I'm hitting you over the head right now. I have a stick behind my back. I will hit you over the head if I don't like what you're doing. I think we also need to be thinking about power in its virtual forms, and I'm using the word virtual here in the sense it was used by an Italian economist, Roberto Scazieri, who talks about virtual production processes, things that we can bring into being using knowledge that we currently have and resources we currently have but which do not currently exist. I think a vivid example of where we spend a lot of energy fighting over power in its virtual phase would be when we're fighting over who gets to engage in encryption practices and who gets to think about encryption. We're looking multiple steps down the road and trying to control it now. We see that in the intellectual property world and so forth. And actually I have to thank the Tallinn manual for this. I'm also adding the concept of sunk power, that is exercises of power in the past. Until I hit the Tallinn manual, I was thinking of that largely as symbolic power. I'm going after you because I hate you for what you did to me 50 years ago. But in the Tallinn manual, there's discussion of what happens when an attack against you may have stopped, but you don't even know it because it's so hard to understand what's going on. And so in the electronic environment, I do think that the concept of sunk power is also going to be of use to us. Side point, since the question about digital and analog came up, I have a distinction between pre-industrial tools, industrial tools that characterize modernity and what I call informational meta-technologies that are qualitatively different from industrial technologies in terms of the degrees of freedom that they enable. So I do think there is some reason to distinguish among the types of technologies we're talking about. That's a side point. We are engaged in what I would argue is the emergence of a global information policy regime that runs across different areas of the law. In regime theory to political scientists talks about principles, norms, rules, and decision-making procedures that come into place are consensually accepted prior to the embedding of those things in bodies of law. In the case of cybersecurity and cyber war, we are talking about existing international law, but I see that as contributing to the development of a regime that goes beyond those areas and runs across all of the terrains in which information law and policy are important. And I use the concept of emergence here in the way that it is used in complex adaptive systems theory to refer to a system the properties of which will not fully be evident until the system itself comes into being. When you looked at the characteristics of the emergent global information policy regime as it stood a decade ago, you saw that the most important concerns were economic, and now I would argue that the most important concerns are actually those of security. I use the phrase information policy as the umbrella concept for all laws, regulations, doctrinal principles, and programs relating to any stage of an information production chain that we can briefly describe as including information creation, processing, flows, and use. More colloquially, we can say this is all law and policy for information, communication, and culture. There are several ways in which cybersecurity has influenced the information policy regime, and I'll be addressing that in these three areas. In terms of regime formation issues, we have the problem that has already come up multiply in the talks and in informal conversations and breaks, and that's the conceptual divergence that comes from the fact that we're bringing together concerns from multiple different areas of activity. One example that comes up in the Tallinn manual is the concept of attack, which means one thing to the military, use of force against a particular target, a different thing in international law when it means a level of force that justifies self-defense. Those are two different things. We have the distinction between law and practice, and it's quite interesting, to me at least, in the Tallinn manual, the number of areas in which the experts are saying we don't know how this is going to go, basically practice will determine it. We have seen that before. The driving force behind the globalization of counter-terrorism laws in response to the UN mandate, of course, was very much Interpol-driven, the details of the UN mandate in that area inspired by Interpol. What that means at the national level as the UN mandate is operationalized within national laws is that many countries have found an opportunity or been compelled, depending on their position, to actually abandon or move away from or radically reinterpret constitutional principles in order to align with mandates that come from practice. So the distinction between law and practice is, I think, quite important. We have the characteristic of legal precession becoming very important, and I take the concept of precession from physics. You're talking about systems that interoperate along a shared axis. one of my complaints against traditional legal analysis is that it always operates as if there's only one kind of law operating at one time in society. You're in the privacy world, and nothing but privacy matters, and you cross the street, and now you're in the world of defamation, and privacy all of a sudden doesn't matter anymore. All of these things are interrelated, and that's very clear in the world of cybersecurity, where, again, in the Tallinn manual, we're looking at interactions with domestic law and with humanitarian law. And then counterterrorism is obviously a key characteristic of this environment. Certainly, I was actually surprised at how little it's discussed in the Tallinn manual, whereas it is certainly echoing, resonant with, supportive of the directions in which that's going and the kinds of problems being considered. It's particularly interesting from a theoretical perspective because this is one of only two conceptually defined threats as opposed to event-defined threats that the UN has identified. When we look at the impact of cybersecurity on the regime itself, the status of the regime, again, we see the impact on the fundaments of the international Westphalian system. Distinctions among stages of the information production chain are important, and this is a running theme throughout many different areas of the law where we are increasingly, increasingly, but it has historically always been the case that we differentially apply the law depending on what kind of informational activity we are undertaking. And so whereas a couple of decades ago we might have just said information processing, now it becomes more and more important to make distinctions among types of information processing, again for differential application of the law. And that was where I thought Santor's actually presentation this morning was particularly valuable and stimulating. In the Tallinn manual, this comes up with mention of the nexus approach, that when you're trying to decide whether or not a given state is responsible or should be held accountable for a given use of force, there's the question of how many steps were in between the effect and a potential action, purported action in which a state was involved. You're talking about stages of information processing there, number of information processing steps, and although the Tallinn manual doesn't get there yet, I expect in future we'll be going to distinctions among the nature of the information processing that takes place at each of those steps. In this environment, then, proximity is determined not by how close the country is to you geographically, or even how close the country is to you geopolitically, but how close it is to you in terms of numbers of information processing steps, in terms of the impact on the state or entity that is concerned. We have interpenetrated governance, meaning that any notion that a state is operating independently or autonomously in this environment from a legal perspective even is, and certainly from a governance perspective, is not going to be held up empirically. That's evident all through the Tallinn manual when they point to the fact that none of it is going to hold water unless and until states put in place their own changes. And so we should expect going forward that civil libertarians concerned about what's going on within their own nation states are going to be paying more and more attention to what happens in international law in the areas of cybersecurity and cyber war. Again, as we saw with counterterrorism, the real effects are on domestic civil liberties often. And the non-state actor question has come up several times as well today, so I won't say anything more about that. I'm particularly interested personally in the impact of cybersecurity on epistemology. It presents a number of challenges to facticity, and let me just briefly define what I mean by facticity, speaking of Locke, who introduced the concept into the culture. By facticity, I mean a social formation in which there's a cultural orientation revolving around the fact, whether that is towards the fact, you're seeking it, or away from the fact, it's fiction and you're denying it. We have in a culture, in societies characterized by facticity, which is all of us during the period of modernity. What was described this morning as hyperhistoricity is actually, of course, what others have been calling for decades postmodernity. But in conditions of facticity, we have specific social forms, specific social functions for narrative forms that present themselves as factual. We have detailed and verifiable procedures by which facts are developed and evaluated, and we have institutional certification of information and information production processes as factual. The challenges to facticity that are presented by cybersecurity include already mentioned the difficulty or impossibility of attribution and or geolocation, deception such as spoofing, and so the suggestion that we might want to replace the desideratum of identification with simply identifying the control mechanism, the control test. And we need to think about the difference in the question of deception when it occurs in the panspectron versus the panopticon environment. The concept of the panopticon is, of course, widely known. It was actually coined by the same Jeremy Bentham who came up with the concept of the international. And in the panopticon, of course, you choose your subject of surveillance and then you assemble your sensors to target that subject. In the panspectron, you're collecting information about everything all the time, and the subject only becomes apparent once you ask the question. So in the panspectron environment, what's really important is not the target of surveillance, it's the question you're asking. And if you're hanging around it all in big data circles, you'll see that, of course, this is where the big data world has gone as well. It's about the question. It's not about the subject. When we're talking about deception in a panspectron environment, then I think we need to go even further than we have in terms of thinking about issues of representation and what they can mean in terms of threat and possible attack and harm. And then the additional facticity issue presented by cybersecurity is the need to correlate many separate acts of events to even be able to perceive whether or not something has been coordinated and distributed. And certainly in US law, where the desire to protect against what are called inference attacks has become very important, first conceived of again in the 1970s, but much more important since the 1990s. This is a matter of great concern. An inference attack is your ability to reach a militarily or politically undesirable conclusion on the basis of information to which you legally have a right of access. And I can talk more about that later if you'd like. But it seems to me that if you are if you are criminalizing intention or targeting subjects of surveillance on the basis of what you're claiming is intention, you're then actually talking about alleged intention, and we get into a very ambiguous environment regarding what may be deception and deception on whose part and so forth. We also have evidentiary issues, and from that perspective, one of the interesting things in the Tallinn manual is that it asserts evidentiary rules. If, for example, information is routed through a state, simply routed through it, that should not be taken necessarily as evidence of the state's involvement. That's an evidentiary rule. Challenges to the international system, some of these, this is maybe synthesizing some issues that have already come up and kind of focusing them on the Westphalian problem. So yes, existing international law applies, but then rather immediately the Tallinn manual goes into the question of how far. Is that completely? Is it anything not forbidden is permitted, or is it someplace in between? There are questions about the objects covered, and when it comes to sovereign immunity, are objects owned or used by a state that are off its territory to be considered immune or not? There's what I'm calling witting requirements, various places where actual knowledge, and there's definitions for actual knowledge in that context, where actual knowledge is required. Can we have witting, knowing requirements in an environment in which there are so many facticity issues, even shy of getting to the technical issues of identifying the actor that should be held responsible? We have the question of agents of concern. This, again, has already come up, the non-state right of self-defense that was triggered by the Bush Doctrine, happy to call it that. The very interesting question about the level of organization required before you can consider a non-state actor to be a threat in the same way that a state actor would be considered a threat in the Westphalian system. Coming out this month is a piece of mine that is looking at the question of agency in networks as it was examined by the US government in the Bradley Manning court-martial, his trial for having leaked all the cables that WikiLeaks released in Cablegate. There were some fascinating arguments that the US government put forward that included basically arguing that They were arguing you could determine cause by effect. So the fact that Mugabe in Zimbabwe took advantage of the cables was proof. They argued that the court didn't buy, but was proof that Manning had intended to aid and abet the enemy. It's quite a powerful argument, determining cause by effect. But they also then went on to, and basically it means anyone who used. So you're identifying the social network, the agent that is subject of the law, by use of the information released by that network. There were some earlier questions about network responsibility. Of course, when you're talking about these kinds of networks, it's the point that they're anonymous, it's the point that they don't leave the legal trails that the historical right of association protected. You've joined an organization, there's documentation of your communications. Theoretically, in these anonymous networks, none of those things are there. So the question was, how do you go after them? So the government said you can go after who uses it. Of course, by now that includes diplomats around the world, it includes courts around the world, it includes scholars, and so forth. Then the government took a step further and actually issued the subpoena, which was then upheld by the court, that they could go after the IP addresses of anyone who was following Twitter about WikiLeaks, which was very interesting. They've so far only gone after 3 people whose IP addresses were identified there, but if you look at the text of the subpoena, it gives them the right to go after anyone who followed the tweets. So then do you get to a definition of, in the world of networks, anyone who is simply following information about, because you're interested in the news, would be considered a part of the legal subject of the network in that environment. We have not yet resolved the question of how to deal with networks as legal subjects. You have the problem of motivation and intention, and again, if you're determining cause by effect, then neither motivation nor intention is important. That would be a significant change in our legal system. And you even get to the point of acknowledgement that even an individual could operate. So from the perspective of a fundament of the law, what is the legal subject? We have enormous uncertainties in the cybersecurity environment. To me, there's a very interesting meta issue, which are the parallels between and the differences between what we are asking of states in terms of intention, in terms of representation, and what we are asking of individuals, especially under counterterrorism law, and that's a path worthy of further attention. We have the question of agency of concern, and here again, the difference between judging, which the Tallinn manual goes back and forth, the difference between judging based on alleged intention or perceived or purported intention or explicit intention, and the effects. The types of effects that matter, this came up with a question, actually your question, I think it was earlier, and I would have in your shoes said, I think the question then would be on how much damage is caused. So the long history of whether or not an economic impact is considered damage. If it means that people are starving to death, then in the end, you could say that it is. But that conversation is, of course, rife in the world of cybersecurity. The question of responsibility for indirect effects becomes very important, and economists, of course, still haven't taken up externalities completely, and this hasn't yet happened in the world of cybersecurity, but is an area in which I believe there will be further development. And then this interesting a question of the level of accumulation. And one of the old questions about, is this an information society, comes up again here. And to me, the answer there has always been Engels' law, that quantitative change yields qualitative change. At some point, the number of things and the number, or in our case, the number of ways in which we are dependent on the information technologies and the number of dependencies is so great, we can say that that the nature of the thing has changed. And I think that's the problem that we're after in terms of when it have single events or single attacks accumulated to the level that we can consider them actually a cyber attack, when none of the individual circumstances would have qualified. And last, we have the question of the phase of power. In the area of security and defense concerns, the issue in the past has been determining whether or not power is actually being used when we get in the world, and we have the world of diplomacy to help us when we are concerned about potential exercises of power. So we had all the rules of warfare We get into the world of confidence and security building measures where they try to get informationally specific rather than looking at the buildup of arms, looking at how information is handled in the buildup towards actual uses of power. The actual versus potential tension shows up in the Tallinn Manual in the discussion of whether or not a state should be held responsible for protecting against attacks that are merely potential, which again gets into 100% of what goes on in the electronic environment. We have actual versus sunk tension in the Tallinn Manual. It interacts with the witting problem, how much do you know about what's going to happen, and it interacts with the nexus determination, how many steps away, how many kinds of information processing would have to take place before we can consider something so sunk that it's in the past and not something currently to be dealt with. And we also have the problem of protecting against the virtual. That goes beyond the merely potential. In my view, the Tallinn Manual doesn't deal with forms of power that do not yet exist, but that can be brought into existence with what we currently know and the resources that we have. So my conclusion is just that cybersecurity issues are not just those for geopolitically recognized states or for the non-state actors that believe they have stakes in what's going on, but they're challenges to the nature of the Westphalian international system itself that join many other factors in reorienting our law-state society relations. So thank you.
Okay, so don't be shy. We're almost to the end, so you're not allowed anymore. Any question, any comment? Oh, please, Joanne.
Brief add, there are a number of publications up in full text on the website.
Okay, now I was just would like to ask you for a clarification concerning the power of the virtual. What do you mean? For instance, building technology, but not putting it into practice, that potentially would having software capacities that would allow.
I would call that potential in the way that you've got a pile of tanks sitting over in the yard, but you're not using them right now.
Okay, but you don't need even to have developed, for instance, a virus that would potentially harm, if it was deployed, would potentially harm the enemy. It is sufficient that you have the technological capacities to develop it, or is it?
I'm distinguishing between identifying that as a phase of power and saying what the legal judgment of the exercise of that would be. So as I understand it, and all of you in the room have much deeper knowledge than I do about security and law of war, but just as we allow the building of tanks and so forth that are only potential because until they're used, so putting in place this kind of system would be potential form of power, phase of power that would be legally acceptable in my view.
Thank you.
Great. Any other? Salva, please.
What are the objects that have power? I mean, what has power?
I just gave a talk on information as an agent, actually, so you don't want to press me too hard because you'll get an hour and a half.
Okay.
In my view, there's actually a six-fold typology of types of information that you can build by comparing and contrasting hundreds and hundreds of things that have been put forward as definitions of information and categorize them along several dimensions. What can hold power? Any of the traditional kinds of entities, individuals, but I do also believe we're at the moment in which information on its own, and here we get into the question of what becomes autonomous, can exercise power on its own as well, non-state actors. I'm not sure if you had something specific in mind behind the question.
Yeah, I'm wondering if we ascribe power, as you apparently are willing to do, to non-persons and to classes of agents composed of non-persons, then what the relationship would be between that willingness and the Tallinn manual and the future. I mean, I think it sounds like we'd be on the same wavelength, and I think these two presentations are related in this regard. So that's really, a major part of why I'm asking. That's the form of power that I'm personally most concerned about. I'm not so concerned about it. 5 people at the NSA realizing that if they do peak a bit, they can save lives. I mean, okay, that may be right, it may be wrong. I am concerned about autonomous and powerful machines not being held accountable, period, because they don't even have that concept. So.
Yes, and actually I was going to compliment the cooks for putting these two presentations together, because I thought they were very well matched. But but I would add to what has come before about, just to use my phrase, information as an agent, that in addition to delegation, which was such an important concept, there are, and the second was autonomously evolving, so we may have designed, we have no idea what's going on out there. The third way in which this can come about, of course, is complexity. And it was in the 1980s that we first saw, in the US, it was the shutdown of a long-distance telephone system for 48 hours. It turned out as a result of complex interactions among pieces of software that were beyond the capacity of the designers to even understand. So I think the Tallinn manual, to me, as far as I understand it, doesn't yet enter that terrain fully.
Thank you.
Would you like to?
So can you go back to the point of your presentation dealing with the very idea of governance and how governance is changing? And, with a specific reference to the complexity of this governance. And by complexity, I mean the fact that this network of institutions and competences are dealing with problems that are affecting the whole network. And in that sense, we can talk about the complexity. Further details about this transformation?
Yes, and actually I would have disagreed with the speaker this morning who distinguished between those countries that have the capacities and those that don't. There is asymmetry in that sense, but it is 100% of us from the perspective that we're all affected by decisions made at the most sophisticated technological edge. I should make clear that for me, governance is opposed to government. Formal laws, practices, decision-making procedures of geopolitically recognized governments. Governance then would be formal and informal practices, decision-making procedures, rules, programs of private sector as well as public sector entities. And governmentality is also extremely important. So it's our cultural habits and deep predispositions that sustain and enable governance and government. In this environment, if you press me into the corner, I would say I think we might be reaching the stage of ungovernability, actually, because of the levels of complexity that we are facing. I'm not at all suggesting we should stop trying.
I think that we might be satisfied with this question and answer. Let's just give a moment to Anna Maria. And so thanks, Sandra, for her talk.